Good morning. Good morning. This is the Procedural Justice in Action Case Studies from the Field workshop. Quick note, there will be a Q&A session. So if you need to ask a question, please go to the center microphone because this session is recorded and it's live streamed. So first I have the honor of introducing John Meeks, who is the Vice President of the Institute for Court Management at the National Center for State Courts. He will be our moderator for this workshop. Directly to my left is Ms. Emily Gold-Lagrada. She's from the Center for Court Innovation in New York City. And last but not least, we have Mr. Tom McCaffrey. He is the Criminal Court Administrator for the 5th Judicial District of Pennsylvania, Allegheny County. So we're in his area right now. So without further ado, I will pass this over to John Meeks. Thank you.
Thank you, Alfred, and good morning, everyone. Thank you for coming to one of the final sessions of the conference. So today's topic is on procedural justice or procedural fairness. The terms are kind of used equally. And the format for today is going to be, after just a brief kind of Q&A about how much you all know already about procedural justice, Emily is going to talk about the research basis of procedural justice. And then Tom McCaffrey, who is here from the Allegheny County Criminal Court, is going to talk about their experience because Tom's court is one of 5 courts around the country that have entered into an agreement with the Center for Court Innovation, and they agreed to be studied and to implement some new practices in procedural justice. So we're going to hear from Tom about what's happening in his court, and we definitely want to hear a lot from you all, which we recognize as a challenge because it is important that if you don't go to the microphone, then someone needs to repeat what you said, and that'll be fine. So remember that. You may have to repeat what somebody asked or said. So the first question that I have is a show of hands. How many have heard the term procedural justice or procedural fairness? So probably 2/3 of the people in the room. And would anyone be willing to step up to the microphone and give a definition, a quick definition of what they believe procedural justice means? I'm a very patient person. Oh, I know someone wants to step up to the microphone. Maybe I should call on someone, because I have many friends in here, and I'm willing to lose one.
Or even, are there any words that come to mind? Maybe it's not a complete definition, but some words that you think of when you hear the phrase?
So due process, transparency and fairness, timeliness, consistency, opportunity to be heard. That's good, TJ. You're going to hear more about opportunity to be heard. I think it is a concept that that is somewhat. It's a big concept. And Tom was talking at breakfast while we were meeting before this session about when you're talking about something that can be everything from making eye contact to structuring your court operations in such a way that that people will feel respected and heard. It's difficult maybe to get your hands around it. One quick example, and then I'm going to turn it over to Emily. I was talking, I think, to Audrey Rigsby from New Jersey, and she was saying that in their probation department, that's where people go to pay child support. So when people go into the probation department to pay their child support, they are treated like criminals, and that it's just it's like built into their system that people who are there actually kind of to do the right thing are going to be viewed as though they are somebody who's on probation. And it's very difficult. And to me, I think that's an interesting example of where the system itself is structured in a way to make procedural justice difficult. So anyway, I don't want to get way ahead of ourselves. I'm going to turn it over to Emily for an overview of procedural justice.
Okay. Can everybody hear me okay? Yes. Okay, this is going to be fun. So I know you guys kind of are asleep, and this is the end of a long day. I overheard someone just now say, this has been a great conference, but oh my goodness, I'm exhausted. So I can relate, but this should be a pretty accessible topic. I'm only going to show one graph. So that'll be the extent of the science that we're going to be covering, at least from a visual perspective. But this is definitely my favorite topic to talk about because it's so intuitive, and because I really think it has really great potential to overlap with so many of the other reforms that are currently happening across the justice system. I think it probably goes without saying that the legitimacy of our justice system is certainly in the public's mind right now. The focus of that has largely been on policing across the country, but as we know from our neighbors and our family, the public tends to see the criminal justice system as one body, right? And we know that that's not always the case. We operate in silos often. But that discourse in policing right now spills over into how people think about criminal court. And about the courts more broadly. So I think this topic, it's good timing to think about legitimacy and perceptions of fairness. And so kind of your crib sheet, your cheat definition to what is procedural justice, it's looking at perceptions of fairness. So we'll drill deeper into kind of what are the elements of that, but that really should be how you think about this. It's about fair treatment. And there's this whole body of research, which I'll outline some of the key findings of what happens when people feel that they were treated fairly. But that's really why we're here today and why probably many of you have already heard about the topic. It's kind of one of the buzz phrases right now in justice reform, and I think for pretty good reason. So I'm hoping that we can explore that more today. So I'm thrilled to be here with John and Tom. As Alfred said, I work for the Center for Court Innovation, which is a nonprofit based in New York City. And I work for our national team, which has the privilege of traveling the country and working with folks like Tom, who are rolling up their sleeves and trying to implement research-based strategies like procedural justice. And so we'll talk more about that project in a minute. So I guess without further ado, John already kind of ran you through our agenda for the day, but we're going to talk a little bit about the research behind it, make sure we all have a good, strong working definition of procedural justice, and then we'll go through some practical examples, some from right here in Allegheny County, but I've pulled some of my favorites from around the country as well. I'll show you some gruesome non-examples, things that I've seen in other courts that are not procedurally just. And you know, of course, they're common and easy to have these non-examples come about. But we'll look at those, and then we'll talk about some resources that are out there, both from John's shop, which is the National Center for State Courts, and as well as the Center for Court Innovation, so that if you are interested in this topic and want to maybe do more, kind of what's available to you to go back and talk with your colleagues, both within court administration, if that's where you are, but as well as other partner groups, whether it's the judiciary or probation or the local defense bar. All of those are essential players, as you might imagine, in this topic. Okay, so first, I want to think about, so pretend you're not at a professional conference right now. Pretend you're just kind of sitting around the dinner table, or I guess breakfast table, as it were. And I want you to think about a time when you were kind of the lay person in an experience where you had to wait in a long line, where you had to interface with a professional who maybe wasn't really explaining things very well, who maybe was treating you disrespectfully, treating you like an idiot. And so the things that I think of, and this may not be true where you live, the DMV is often the butt of these jokes, but other things, the IRS is another one. Insurance, my husband and I just recently had our upstairs neighbor flood their bathroom, and all of the bathroom water came flooding into our apartment. So for the past 8 months, we've been dealing with their insurance and our insurance, and I think every phone call reminds me of procedural justice, not in good ways. So anyway, if you can, think of a recent example in your life like this, and think about kind of what are the things that made it so frustrating. What were the aspects? Are there certain things that somebody said? And did you have ideas as to like, well, why wouldn't they have just done it this way, right? It would have been so much more humane and approachable if they had just done X or Y or Z. You have some examples. Does anyone want to share just quickly? We're kind of a small group. Anyone have a story, a short story they want to share? Yeah. And if you can, thank you.
This is sort of an embarrassing story, though. But going into our own family division court, I'm with court administration, but I'm not in family division, and I don't actually know where the employee entrance is. So I had to go to a meeting, and there's a long line, and everyone's taking off their belts and, their shoelaces and whatnot, and the security guards are so mean. They're just, and I'm in line, and I buzz. I go through like you're supposed to, and I buzz, go over there. And so I have to go over there, and they have to wait for a woman to come and scan me, and the woman doesn't come to scan me, so the man comes, he's like, it must be your bra. I was like mortified, and I'm like a professional in the court system, and I'm like looking at his name thinking, I'm going to go complain, but then, Tom entered my head, and I didn't go complain. But that was just an example, like, I really wasn't a lay person, but that whole experience really bothered me afterwards, and I thought, he could have been more sensitive about whatever, and it really wasn't my bra. I don't know what it was, and I'm like, thank you for your kindness and whatnot as I go in.
Right.
But I don't know if that's what you're looking for, but that was sort of an example.
Absolutely, thank you for sharing. That makes me think of my other favorite butt of these jokes, which is TSA. So I travel a lot, and there are good experiences and there are not so good experiences. And yes, so security procedures, that's a direct analog to our world, right? Do many of you have employee entrances that you get to use? Anybody, employee entrances? Have you gone through the public entrance recently? Yeah, and is it different? It's probably pretty different, right? And so it's a great example to kind of, it's almost like a secret shopper, right? To pretend you're just a member of the public and go through the main entrance and remind yourself what it's like to go through that when, try to forget all the things you know. And go through that process is a great example. Anybody else have a quick story they want to share? Anyone? No? I'm not as patient as John, so I guess I'll move along. Okay, so obviously if we think about a better version of those stories, we could maybe imagine a way that the security officer would have handled that flag better, as opposed to calling out, a woman's undergarments in that story. But there's some kind of just interpersonal things, right? How to phrase a question, how to, what's the appropriate tone, things like that. But there are also some kind of process things that could make things go more smoothly. So in the DMV example, and I've even seen this in courts, in kind of a court lobby, but take a number, right? And then you kind of know when your case is coming up. You're not sitting there clueless as to when you might be called. And so there's some kind of comfort in the process. You understand that I'm going to be called when C526 comes up, right? So those are the types of things that we're going to be looking at under this umbrella of procedural justice. Okay, so I think a nice place to start in thinking about why we're looking at procedural justice is reminding ourselves what are the goals of the justice system. So I put up a few or two examples up here. Can somebody add to this list? So is this missing anything? So I say accept, and we want to handle people's problems so that they accept and abide by the decisions. And we want to enhance the trust and confidence in the justice system. What else do we want the system to do? And I can repeat back what you say if you don't want to go to the mic. What should the justice system do? Why do we go to work? We want people to feel heard. Okay, so it's a part of government that is a receptacle for people's issues or complaints or concerns. What else? Oh.
Just at the beginning of the window, because we have like a walk-up window, and I think at that point, we don't know. You should definitely talk. Okay.
Yeah, that sounds like it's going to be a juicy answer.
I'm sorry.
Nope, thank you.
I think what people would like for us to do as court administrators or just people from the court, when they first walk up to the window, whether we don't know if they're there for court or a court question. However, I think sometimes they just want to feel respected from that immediate contact at the first moment that they come to the window. I've had someone to say that I wasn't here for court. However, I felt like I was already a defendant with a problem or with the issue. And I don't think when people walk up to our window, they should be made to feel that way. I think that beginning of the respect starts there as soon as you have that moment of contact.
That's such a great point. Thank you. And that's similar to what John was talking about, right? Is some, and this was maybe a more clear-cut case, but if you have child support payments in the same place as probation or reporting, those lines can be very blurry for staff. So maybe you separate them, or maybe you reinforce for the clerk or for the staff member that it doesn't matter why somebody's coming to that window, right? Everybody is due a certain level of just human dignity and respect. And that is really underlying this. And again, we'll get to that kind of research basis in a minute. Mm-hmm.
I think it's interesting too because it's certainly
How about I can attempt to play Vanna here, or if you want to. Here, I'll start you out.
I think it's important to know at certain public access points, and specifically filing offices, you have general public and you also have professionals that deal with the court system, attorneys, things like that. And as you have people standing in line, you tend to notice that staff may be dealing with attorneys or people that they see on a regular basis in a different way than they're dealing with members of the general public. And that's an obvious disparate treatment issue. I think we need to be aware of that as well.
Thank you.
Vanna?
Yes, but just a few rows behind.
I think we need to provide them with resources, alternative resources, because sometimes people come to us in the probate court and they don't even really need to be there. For instance, if there's a vehicle in the decedent's name, it's possible they can go to the Secretary of State's office and fill out an affidavit with a death certificate and have that assigned to them. If it's life insurance and they have a beneficiary designated, that doesn't need to go through probate. So sometimes we tell them, hey, you might want to try this first. We can't tell them what you should or shouldn't do, but you might want to try this first. This is something that you might be able to do to avoid probate and probating certain assets. So I think we need to be willing to provide them with some alternatives and other things they can try.
Great, thank you. So yeah, kind of seizing the opportunity that here we are, and it's maybe a counterpoint to the first comment. So we want people to have a chance to be heard, right? For the government to hear the public, but also for the government to provide back. What are the resources that we're aware of, right? We're kind of this repository of information, and so how can we be helpful? So we've heard things like voice and helpfulness, so remember those words because they're going to come up in a minute.
I think one of the goals that I hear isn't from necessarily our side, but from everyone where I work with and I see every day on the front lines, it's their time. That's what I hear. They want us to get them in and out the door as fast as possible, and that includes from the security when you walk in to getting in the courtroom and having the judge and court personnel ready, and they want in and out. So that's what I hear. That might not be a goal of ours, but that's what they want.
Great, and that'll come up, I think, at other points in our discussion. So yeah, doing all of these things quickly, if not efficiently, or both.
And consistency as well.
Consistency, yes. Good. I think we've actually fleshed out the definition of procedural justice already. You've done it for us. So we're going to come back to these things. I'm going to move along. So before we do that, I want to drill a little bit more just into kind of our specific role, each of your specific roles. So is there anything that you want individually, you and your colleagues, when you show up at work that hasn't already been raised? What makes you have a good day at work? Somebody brings in donuts. I know that's my answer. Let's see, where'd the... I'm sorry, I know. You're going to regret volunteering for this.
I was going to say when the judge has a good day.
When the judge has a good day, yes. Okay, good.
When the judge shows up on time.
When the judge shows up, that's an issue that comes up many places we visit. What else? What makes you feel, what gives you job satisfaction? Something does, I hope, yes.
Get a compliment from someone about a project that you finished.
Okay, getting a compliment.
Yeah, or if you're on the phone and someone says sincerely that, thank you for the information you gave me.
Great.
That feels good.
Getting thanked and acknowledged for the hard work you've done, for putting in that effort. Anything else?
I think for us in tribunals in Scotland, it's quite good when we get feedback from our users about they had a fair hearing. They might not get the decision that they're looking for, but they were heard and they were able to put their side across. They might not always get the decision that they want, but they had, they got their hearing. So I think that's satisfaction.
Great. So yeah, kind of hearing the satisfaction among court users. I mean, that's kind of maybe a similar, common thread among what you're saying is that your jobs are easier and more satisfying when you feel that the court users are kind of having their day in court because the judge showed up and the judge was, having a good day, and that your hard work paid off, and that the people you work with or work to serve are acknowledging that. All of that makes sense, right? So that cues us up to this topic, which is something that just, what do all people want? And so the research that went into procedural justice was a bunch of psychologists who sat around thinking about what makes people obey government or obey the law. And they did a number of studies. They looked at police stops, they looked in prisons, and they spent tons of time in court, all different kinds of court, family court, criminal court, high dollar kind of civil litigation courtrooms, small claims court. And through all of that, they wanted to tease out what makes people, plaintiffs and defendants, adhere to the judge's decision or to the court's decision. And the hypothesis was tied to something, and I don't remember who said it, but this idea that you need, and I think actually it was you, this idea that people want to feel respected and to be on equal footing with their peers. And by peers, we really just kind of mean other grown-ups. So when you start out an experience and someone particularly in a position of authority, like you all or like the judge, if that person is demeaning and disrespectful and doesn't make an effort to explain the process, those are the situations where people tend not to adhere to the court's decision. By contrast, when they were in courtrooms where all of those things were happening in the favorable way, meaning that those interactions were respectful, the court user had an opportunity to voice their side of the story or ask questions, they noticed that in those cases, those people adhered to the law. They followed whatever the judge's orders were, or the court's orders. So that's the underlying research in a nutshell of procedural justice. So it all came out of academia, which is kind of unique. And so we're at this moment in time, and really just over the past 5 years or so, we were talking about this over breakfast, where you all are now trying to figure out, like, well, how do you put that into practice? So how do we take that research and kind of operationalize it, go home and figure out what policies court administrators or others can implement so that we're kind of taking advantage of the wins, that when you do these things, you get people to comply with the court's orders, which wasn't necessarily, I think that was kind of implied in the goals of the justice system, right? The justice system works if people do what it says. If no one follows the orders, then we might as well not go to work. So anyway, so what people want generally, and that's us when we go to the DMV, and it's me when I call my insurance provider, my insurance company, it's us when we show up at work, right? We want to feel respected, and certainly court users. So it's all kind of the same things. There's no us versus them. It's just what people want. So that is where we are with our definition. So procedural justice is the perception that you're treated with respect and that your concerns are taken seriously. So this isn't me making up these words. This is all of that kind of academic rigor that went into it. John mentioned that sometimes this is called procedural fairness. That's just semantics. You can choose which resonates more with you. But I'm glad somebody brought up earlier the phrase of due process. Because due process is actually a kind of complementary concept, but it is different. So you can have due process and not have procedural justice. Some of you, I personally have sat in a courtroom where the judge was impeccable on the record. If you were to read the transcript, it was like model courtroom activity. But if you were to sit in the courtroom, you realized that nobody had any clue what was going on because he spoke so quickly and he never looked up from his desk, and so you didn't even feel like he was addressing anyone in particular, right? So that's where you could have due process, but you're missing out on the feeling that the court users were respected and that their concerns were taken seriously. So I think ideally we have both, but they're not necessarily kind of one leads to the other. Okay, so these are the 5 elements of procedural fairness or procedural justice, those underlined words. And as I said, when you have these things, people are more likely to accept and comply with the decisions that the court produces. And so you'll notice that I think we came up with all of these actually in one way or another when you were kind of brainstorming what you want and what kind of the goals of the court are. So the main one is respect, so dignity and respect. And there are lots of ways we can do that. Interpersonal treatment and just how we address someone, good morning. But also in policies. And usually one way to think about it is kind of on the flip side. What are things that our courts do that are just blatantly disrespectful? It might be security procedures. It might be the comment earlier, court always starting late, right? This is an issue in every court I've ever visited, so when you solve that one, let me know, and I'll tell your friends. But so yeah, there might be some kind of process things that are disrespectful that if we can improve, maybe not solve completely, but if we can improve them, then you're adding to that respect factor. Understanding of the rights and process associated with the courts. And that's a hard one. Often we hope that defense counsel is providing this in a criminal context. Usually they are. But what are ways in which the court can support that? So whether it's a pamphlet, a lot of courts, including Allegheny County, produce handouts that just clearly outline the process. And maybe it is Also helpful to the staff because it means they don't have to say it, 150 times a day. They can just refer to the handout. But there are things like that that probably you're already doing that you can make sure are achieving that understanding element. Having a voice in the process, that also can be something that sometimes we want attorneys to help with. Right? Attorneys may not want their client to have voice during a criminal proceeding if they are going to say something that is incriminating. But all of us can make sure that there are other points in the process, whether it's at the window, if there's kind of a clerk's window. Another great example, which I think we'll talk about more later, is a court user survey. Does anyone have a kind of feedback form in their courts where someone can fill out a complaint or rate a few places? And does someone actually read them? Yeah.
Online as well, so they can go onto our website and give us feedback, after the actual hearing or decision's been issued. So,
Great.
And we get really good feedback.
Excellent. And good feedback because it's all positive?
No, not necessarily,
Right.
but we're able to then act and maybe put something. We have a bit on our website where we'll say, you said we did. So, we're reacting to what they've said. I mean, we can't always, sometimes they refer like, oh, we didn't like your website. We'd like it to be more like Debenhams, which is a department store. Nothing that we can really do, but, it's really good feedback.
Right. Good. And so what's great about that is not only is it providing you with information you can act upon, but just offering a survey is giving people voice. So you can check off the third box just by having that available. Did anybody else have something they wanted to say on that point? Oh, you're really getting a workout. Thank you.
Yeah, we have one in my court, and it's real time. A lot of times I see my version of it, criminal traffic, which isn't really that positive most of the time. But overall, as a court, it's pretty good. But a lot of times, I think you touched on earlier, not everyone sees us as just this one entity. A lot of feedback is from, well, the officer said this, and then you come to my court and you can't do that. So there's a lot of things sometimes that don't really fit overall for what we do. So.
That's a great point, and it's something that there are a few good points there, but the last one is something that may be relevant to you all. We hear a lot how clerks and other folks in kind of court administration are often undoing kind of bad information that people have gotten. So that might be another thing to just think through. So what is your role in providing that kind of respect and understanding and voice if there may have been prior interactions with the system that weren't delivering that? Okay, the fourth one is in some ways the trickiest, but it came up kind of in the transparency comment that someone gave. So it's essential that the process not only be neutral, but it's perceived to be neutral. And so that's kind of a subtlety, but one that is really important and often overlooked. So I think courts very naturally pride themselves in being neutral, or hopefully they do. But if you sit as kind of an outside observer in your court, and if you didn't know why things happen the way they do, you might wonder if that guy over there with the private attorney, why is his case being called first? What might be maybe untrue, but what might be an assumption someone with a public defender might have when they see that happen? Preferential treatment. Yeah, the guy who can pay for a lawyer gets to go first because he has money. His time's more valuable. Yeah, so there are lots of things like that maybe we're not going to change the process itself. That's a question. But at least explaining why things are happening that way, because you may know the underlying reason. Thinking about ways to communicate that to the public, to defendants, as well as to their family members and witnesses, et cetera, who may be in the court. Those are ways that you can get at that perception of neutrality. So I think that one's really essential. And then lastly, being helpful. And this is an easy one, I think, with this crowd, I can already tell. But just a little kind of footnote to give you some context. So when we started talking about this topic with a multidisciplinary court audience, the judges we talked to told us that they wanted to lop off that element. Because they said it was ethically concerning to think of being helpful. And so we decided that if you could do the top 4 things, then probably you would get across the helpful aspect. So in many of our presentations to judges, that 5th one is kind of oddly missing. But from what you all have said, I can tell that this is a very comfortable element to think of, and one, I mean, we've seen in court administrations having almost like a customer service mentality of how you think about working with the public. And so this, I don't think is a controversial one in this audience, but it highlights how as you're kind of thinking about procedural justice and rolling out possible practices alongside other agencies, you might have to think about what are going to kind of rub certain people the wrong way, and how can you navigate that and still achieve kind of the end goal, which is to promote the essence of this. So, any questions about the elements?
I have a question about the research.
Yes.
Obviously, you looked at all case types. So did you look at, when you're saying people are more likely to accept and comply with decisions if the following are met, is that including like probation conditions? Is that including protection from abuse orders, things like that? I mean, is there more of a civil research base?
So good question. So this research started back, I think, at least in the early 90s. So there's a ton of it, and it is fairly comprehensive. I know that they've looked at a range of civil cases and a range of criminal contexts. So they've looked at very serious felons. They've looked at misdemeanor dockets. They've looked at child support cases, which obviously would not be in criminal. I don't know if they've looked at just domestic violence cases specifically. So probably not everything is covered, but the punchline of the research has been so consistent no matter who you look at, that we're all feeling pretty confident that it remains true with various types of cases. So it's a great question. And it's worth underscoring, I mentioned the civil context only to say, or specifically to point out, that it doesn't matter why you came to court. So if you're suing your neighbor, if these elements are present, you could have the same level of satisfaction as the neighbor that you're suing, regardless of the outcome. So the process is what's most important, and that's another finding we'll talk about in a minute. Yes?
Juvenile matters.
Mm-hmm.
I think in juvenile matters that connection would be an important variable, that kids are more likely to accept and comply if they feel some connection with the caseworker or with the probation officer, because they may not have some of those other variables. Like, they may not feel that they were heard. Someone's always speaking for them. They may not get the concept of neutrality. Respect, they certainly don't understand the process quite often, but we have a saying, no correction without connection, because relationships are important to young people and necessary, and that piece seems to be missing from the list.
That's great feedback. And does anyone else work with juveniles or young people? A couple? Great. And so forgive me for omitting this, but so we can talk about young people. So the research that's been done on this is with adults. And the psychology that underpins it is about how adults kind of make decisions and think about kind of their relationship to their peers. So the field is very actively trying to figure out what of this does apply to young people, because young people interact with authority figures very differently, as we know, than grown-ups do. And so I think some of these things, like respect, probably are pretty universal across age. But yes, I think this does need to be adapted for youth because of their, they just have a different kind of place in the world and have certainly a different role with authority figures. Thank you for that. There's a great study that was done in Washington State. I don't know if anybody's from Washington State here, but the study wasn't designed around procedural justice elements, but they basically did an overhaul of all of the judicial colloquies and the probation forms used with their juveniles. And they studied how much the young person understood about their probation sentence before, and then they studied after. And as you might guess, before they made the changes, young people, I think on average, could tell you 3 out of their 17 conditions, right, when you interviewed them right after court. And when they did the intervention, designed at being more clear, the forms were written at the appropriate grade level, things like this, the understanding of the conditions went up dramatically. So I think there are projects like that are kind of getting at the same things. And so that might be worth looking at if this is of interest to you. Yeah.
I just want to add by saying, if we can be more helpful, then maybe they will be able to understand the process and also have that voice in regards to what they're there for and how the other things can kind of line up with. The helpful is going to be important with the juveniles. Mm-hmm. Because they need to feel that someone is there to help them so they can understand the process.
Great. Okay. And John, wave at me if I think we're okay on time, but. Okay, great. So I want to so we just went through the elements again, so we're good there. Okay, here's the chart I promised I'd show you. So this is important because it kind of undoes some bad intuition that a lot of us have, myself included. So what this says is when you try to ask people, or when you ask people why they accept decisions, you can look at it based on the outcome or the experience, right? How they feel they were treated. That's procedural fairness. And especially if you ask lawyers, what do you think would impact their likelihood to follow the decision of the court? They'll tell you like, oh, well, whether they won or lost, right? People who lose are grumpy and they don't do what you say, and people who win are happy and they walk away pleased. So in a criminal context, that might mean somebody who didn't get the sentence that they wanted, or they got jail time versus not, et cetera. So all of those studies that I mentioned, whether it's civil or criminal, no matter what that context is, procedural fairness, the green bar, is consistently much more prominent in affecting people's decision acceptance than anything having to do with outcome. And this always comes out if you can look through complaints that you might get, that kind of repository of concerns that people have. Usually it's about how they were treated, as opposed to, I'm really upset that, that I lost my case. But usually it's because of something someone said to them, nobody let me, give my side of the story. It's all of those elements as opposed to something tied to outcome. And so even just this kind of shifted framework is something that's helpful as you think about how to implement procedural fairness. Okay, I'm going to duck back over here and get us to, thank you, John. It's so important. That's okay. So, can I have one more minute? Okay, so I promised you guys I would show you, here's some myths, and these are available, the slides, so you can read them tonight before bed. Here's our friend again. Okay, so bad examples. And these are subtle, and they're signs. Signs are kind of easy to pick on because you don't have to be there to really see what was happening. So the one on the left, I think we can see why that's maybe not ideal. Which element of procedural fairness is maybe missing most obviously? Maybe respect? I don't know. Okay. This one on the right is subtle. This is a directory in a courthouse in the Midwest. A lot of courthouse directories look like this. And the problem with it is you can't read it. So these are those little plastic letters that you have to like insert one by one, which is a pain. So when somebody, when Judge Watts retires, they just take him off and put in, Judge Alvin or something. And so it's not alphabetical, the room numbers are all crazy, so you'd have people just staring there, not really understanding the process. This is from New York City, so we haven't figured this out back home. So just be on the lookout for things that look kind of like this. And again, signs are a good starting place. This is maybe another subtle one, and we kind of talked about a flavor of this in terms of the order in which cases are called. So there may be a good reason behind this sign, but think about what might be a perceived reason behind this sign, right? That kind of neutrality piece. Okay, that was my 1 minute. There we go. Okay.
She skipped a bunch of stuff that was really good. In those signs, we have one judge in our courthouse who had so many signs on her door that she started posting them on the wall going down the hall. It was fairly ridiculous. Anyways, I count 37 people. Thank you for still being here. You're either really, really connected and care, or you couldn't get a flight out or something. Whatever, either way, we're here. I had a couple things I wanted to talk about, and when Emily asked me to be part of the panel, first thing I said is I'm not an expert in this subject, nor are we a national model in this subject. We do a lot of things in Allegheny County very well, and we are a national model for some of the stuff we're doing with reentry and pretrial. But this is still an area where we're really trying to grasp sort of a plan to make ourselves better. And I have a hunch that most of you are in the same boat. Is there any of you that think you're a national model or doing everything right? Are most of you doing the same thing we are, just sort of we're implementing stuff we know are good to do, but with really no cohesive sort of plan of across the court of what to do? Because that's really where we're at. Just as a little background, Allegheny County, our population's 1.3 million. We're a second-class county, and all that means is the county encompasses more than the city of Pittsburgh. So we have the Pittsburgh Municipal Court, which processes 63% of all our criminal cases. The other 37% of the cases come from the rest of the county, and there are 46 district magistrate offices that adjudicate these cases, geographically spread out really, really wide. And it gets some challenges. It's very challenging. Trying to get 46 municipal judges on the same page with anything is like herding cats. I mean, it's really a challenge as far as that goes. We process approximately 20,000 cases through our criminal court every year with 14 judges. Our court has 52 judges total, 14 judges doing criminal work. Mostly these judges do a really good job. We have 7 problem-solving courts encompassing over 1,100 offenders, which we do a really nice job with. We have 2 expedited dockets and 1 diversionary docket, which takes about half of everything off our docket, which is, again, good for expediency. How the procedural justice sort of topic came up, we did court-wide strategic planning back in 2011 and 12. And in doing that, we did a survey. So we surveyed over 1,700 people. And Katie's our analyst, and she's laughing because the survey was, when you look at the results, it was intriguing. So there were three categories of people. We did judges and staff. We did attorneys and stakeholders. And the court user litigants, which not only they're defendants, witnesses, jurors, victims. So interesting on the results. We surveyed in 5 key dimensions: accessibility, timeliness, fairness, quality, and external communication. So we did relatively well, and I think Ann Herod would think the same thing. When we got the feedback, it wasn't that bad, but there were some disparaging things that brought this up for us. In regarding timeliness, right? So judges and court staff, we rated our timeliness significantly higher than pretty much everyone using our court. So we thought we were doing pretty good, but not really. And our overall performance was the same way. We thought, from the judges and the employee standpoint, that we were really doing a better job than we were. And that's what got us started looking at this. So coming from that effort, we had 5 committees that convened to work on specific issues. And we did make some progress. We did some improvement, but again, without really a master plan. Some of the stuff we did that affects what we're talking about today, we expanded the use of video conferences, which sped up probation violations, it sped up bail hearings. We updated our forms, which really we didn't look at for years. You know, I was supposed to be running the criminal division. I had no idea what was in some of these forms. I mean, it was ridiculous. So, and that process took a while, but that's stuff that needed done. We developed an information sharing email, so we were able to do e-blast to court users. So our court manager went around and signed up, you know, we went to the Bar Association, signed up people so we could get information out to some of the court users. Wasn't very fancy, but it was effective, and at least I thought we were moving forward. Our committee recommended time standards for criminal proceedings. Now, that was a lead balloon, right? So when we looked at national standards for court processing, I don't know, we were talking about this at breakfast. I don't know what jurisdictions they can do stuff this fast in, but we're like almost a perfect medium-sized jurisdiction, and these are really lofty goals. But we come up with what we thought were achievable standards, or were much faster, much more expeditious than we were doing, and we kicked those out to the judges, and we were encouraging compliance with that. Like mentioned before, we did information pamphlets, and we did some other stuff like staggering the arraignment schedule. Again, we were talking at breakfast, and when I come on as criminal court administrator, we subpoena all for one. Oh, you're going to take pictures?
For the annual report.
So we subpoena, like most of you probably do, for our arraignments, we subpoena everyone for one time, and you'd get a zillion people there. There'd be waiting hours, and so we staggered, the appearances, and it was more difficult than you would think, because the district attorney has a lot of manpower in the way they process cases. Public defender needed to change their staffing. So, we did all these things. The point is, we looked at procedural fairness, procedural justice, and we're kind of haphazardly doing all these things. We still have some challenges. And so when BJA in the center put out a solicitation for an outside evaluation, we jumped at the chance to get somebody to come in, tell us what we're doing good, tell us what we're doing bad, and sort of help us get a framework that we can address this across the system. And that's really where we're at right now.
Hello?
Tom, one of the things that you mentioned at breakfast was about the role of court clerks in your criminal court. And can you tell us about their impact on procedural justice?
Yeah. We had a hell of a conversation at breakfast, incidentally. It was like a 2-hour breakfast. But he paid for it, so we were good. In our jurisdiction, I'm sure it's like that pretty much across the country. Our court clerk assigned to the courtroom full-time has a lot of sort of authority how that docket's handled. It's not so much the judge as it is the clerk. So that's back in our court, for us to instill in our clerks the whole idea of how to schedule things, how to keep things fair, what to put where. They hold a whole lot of power on what the judge does. Now, they work in parameters of the judge's schedule, when the judge wants to come in, how long they want to sit. But the clerks, the key is if you can get your clerks cognizant of how to treat people, how to get the docket flowing, it really allows for advancement of not only timeliness, but that whole court experience. And we had good clerks and bad clerks like everybody, but the bulk of our employees are really good, and the bulk of them get it. That's the main thing. And another thing we're trying to get from the grant is training. When we had those committees after the strategic planning, one of the things was, okay, I understand it, a lot of our folks understand it, but what about specific training? When I can get the clerks in one room, get some people to come in to sort of, go through this whole process, and same thing with the judges and the lower court judges. Get everyone on board to start that sort of change process. Because cultural change, no matter what you're doing, is difficult, and it never happens overnight. It takes a long time, you have to stay at it. So that's one of the things that we were looking forward to.
And speaking of that, what was the process like for you getting the judges in agreement to proceed with applying for the grant and going through the process, evaluating and making changes?
Okay, they're recording this. Our judges are fantastic, and okay, the bottom line is, from the very top of our pyramid, right? So our president judge, our administrative judges, we're lucky and blessed because they're proactive. Changes in anything you're trying to do. If you have a department director or some folks down here in the pyramid that want to make changes, and the folks with the power don't understand, that's a battle. We had a very connected president judge, and the prior president judge was very connected. And really our changes were driven from the top down, which we had an advantage, which a lot of jurisdictions don't.
What are some questions that you all have for Tom with the experience that they've gone through?
Any more questions?
How did you stagger your arraignments?
Okay, we did 8 o'clock subpoenas back in the day. So what we did is we did it in 1 hour increments between 8 in the morning and 2 in the afternoon. So that really, when you look at it that way, we spread it out and through lunch. The way it was before, everyone showed up at once. There was just a pile of people, to process through, and you had long wait times. Now, even if somebody shows up not their subpoena time, so if you're subpoenaed for 11, you show up at 9, we'll still pull it and process it because the crisscrosses weren't as bad because we were staffed to do that.
And just to follow up on that, each district court has specific times that they assign their cases. So everybody from like District Court 1 goes at 8 a.m., everyone from 3 to 4 goes at 9, and that's how they determined who goes at what time period, looking at, I believe, like the higher volume courts as well. And
Yeah. That's it. And Ann Herod is she's the administrator over the lower courts. Her job's way harder than mine.
I have a question. I'm cheating up here because I have the mic. How do you balance this goal of efficiency and expediency with making sure that people kind of have their day in court and understand the process and feel respected? Is there tension there, and how do you address it?
Yeah, there's tension. We struggle with that just like anybody. It's a sort of a two-edged sword. We made some major advancements with our docket. Our age of our, the court tool measures, age of the pending caseload and the, case disposition percentages. But again, the way the pendulum swings backwards, are you rushing cases too much? Are you pushing people? Are people coming through the process and not understanding it? It's a two-edged sword, and we still struggle with that, right? So, thing is, our partners are really engaged. It's one thing we do here really well. We're really engaged with the public defender's office. He's my best buddy because I keep advocating for more money for the public defender because we don't even have a public defender at first appearance. So at first appearance, when they're setting bail, there's no lawyer there for the defendant. All you have is the magistrate and the report from the police, and it's a little bit of a one-sided thing. So that's something again in this vein that we're trying to correct. That we're trying to have more due process at that very first appearance. Now we've adjusted to that, by having a system where if a bond is set on a case and the bond's way out of whack with the criminal history and the risk assessment from pretrial, we take it to the criminal court level. Our president judge will sort of reset bail, and he does that daily. The lower court judges don't like that very much, but it's a way to sort of make sure people are treated fairly and treated in accordance with the risks that they pose for their release.
Any other questions about the experience in the Allegheny Criminal Court? Be thinking, while the microphone's going over to Jen, about issues that arise in other divisions of court. Obviously, Tom is talking about criminal court because that's his court. But just as with the example from the juvenile court about there's no correction without connection, there are certainly other divisions of court with particular issues, and we'd like to hear your questions and comments about those. Jen?
I think I'm remembering that your county is a home rule county. Is that correct? Did that have any impact, the fact elected versus appointed positions? Did you think that had any impact on the buy-in that you got when you were doing this?
Why don't you take that, Ann Herrick? She has her back to the camera since we're recording this.
I'm sorry. The home rule affected us more with our Department of Court Records. Okay. That position in some departments, that's a clerk of court's office, used to be an elected position. Now it's an appointed position by the county executive. And what I was actually going to ask Tom was, and I think there still may be a disconnect because that doesn't fall under the judiciary. So we don't, I don't know if you've trained those employees or reached out to them. They've had a little change in administration in the last year. But so the first place people go to file a civil complaint or a summary appeal or something like that technically isn't run by the courts. It's run by the executive branch of our government. But we have a very good relationship with the executive branch of our government, so I think that's helped as well. But I don't think, other than that the home rule has changed anything else. So does that help?
Immensely.
Pardon me?
It helps immensely.
How about some comments about other divisions of court? Issues that you see, concerns, solutions?
I have something to say, and maybe it's because my specialty is in the minor judiciary, but when I go to all of these conferences and whatnot, that is one place that I feel is under-recognized and under-studied, and if you looked at the case numbers, the majority of people, that's the only court they've ever been involved with, is your small claims court, your traffic tickets, your non-traffic tickets, and, it's the only court they've ever seen and the only court they'll ever see, but I think it's the court that's studied the least. It's just my personal experience. I don't know if you agree with that in traffic or not, but yeah, and we're not in the business to bring money into the system or whatnot, but that is also the place that funds a lot of your courts, realistically. But it's just something for the higher ups to think about in the future. I've gone to a lot of conferences and whatnot, and it's just an area that's never discussed because I don't think it's interesting or sexy enough to discuss. But it's an area that I think the majority of the population, it's the only court they know.
I think another one with the numbers of people who don't stay married is domestic court. If half the people or more are getting divorced, there's an opportunity to have an interaction with basic taxpayers and treat them fairly. We do things like have PDF fillable forms on our website. We schedule their dissolution not in a group, but for a 15-minute block as quickly as we can, usually within like 45 days or so. So I think that's another great way to interact with the basic taxpayer and give them a good impression of how they can be treated with respect at court.
Oops. Okay, great. This is great. What other comments are there? Promising practices to add to our list. This last comment was great. As you think about, when you think about how you might implement this, thinking about those high volume touch points is so smart. Because obviously that's where you're going to get the most bang for your buck. And hopefully if you're able to do some type of user survey, right, that's when you're kind of hitting the most people who are going to give you feedback on how that's going. So what are the touch points in the process that are going to be most efficient? And so I would just, and you would want to be careful that you're not maybe, we've talked with jurisdictions that, for example, will improve juror orientation and maybe not tend to what criminal defendants are experiencing or crime victims right? So you want to make sure it's kind of cutting across a range of user experiences, but looking at those high volume ones is very smart.
I thought that Tom had a really interesting observation at breakfast, which was that there isn't a checklist for procedural justice, procedural fairness, the way that there is now, say, for drug court, where if you're going to establish a drug court, these are the things that have to be implemented in order for it to be considered a real drug court. If you're going to evaluate the program, then here's what you have to measure, and you have to know what you're comparing it against, and so that is something that I know Emily's going to be hard at work on. But the problem, the difficulty is that, just like Emily said, procedural justice cuts across all court users and all case types. And so coming up with the best practices and the checklist of things to implement to demonstrate that you are a procedurally just or fair court is a difficult thing to do. And ICM, the Institute for Court Management, which I'm the director of at the National Center for State Courts, is going to be developing an online education program with State Justice Institute funds. And so we are coordinating with the Center for Court Innovation, and we're trying to create an online product that will be most helpful. And so we're trying to hit the right audience and to achieve the right objectives. And one thing that I realized this morning in our conversation was that at this point I'm not exactly sure where to target that online education program, because there's education for individual court staff in how to treat people who come through the court. And then there are the organizational and structural issues. For example, Tom also mentioned at breakfast that they have an expedited sex offense docket, because they would have the same process where victims and witnesses would be coming to arraignments and other hearings where nothing would necessarily happen, and it would simply be scheduled for a later time. And so they've expedited that. So clearly that is a procedural justice improvement that they have made that has nothing to do with making eye contact when you speak with someone and that kind of thing. So any kind of feedback about like the kind of education that you think would be helpful online? Elizabeth?
I'm just envisioning. 2 points. One is, as Tom said, if you don't get the top of the pyramid, nothing's happening. Well, that's not what he said, but that's what he meant. So
I pretty much said that, really.
So in terms of aiming it, you get to the judges first, because if they need to be the leaders on it, that's essential. The second point is, I think an easy thing would be a bench card of sorts coupled with your online thing. And if you go to the Court Tools user survey and look at those questions, it's almost written for you. Do you feel safe in the courthouse? Do you know what's going to happen next? Were you treated with respect? You know, those questions are there. If you flip that, aim that as your targets, you're going to get a lot of it accomplished, I think. But if you get the judges involved first and court managers, then I think you're tacking it top to bottom of the pyramid, if that makes sense.
I think you should do two.
So do one at the staff level. You could even orient it to new court staff that courts could use across the nation in terms of what does it mean to be a court employee and how do you instill trust and confidence into the courts from any job and real globally like that. And then a second one, more organizationally, targeting leadership, judges, saying how do you look at your organization to build that as a foundational thing or shift your organization so that you have more procedural fairness in place. But I think trying to do both at the same time doesn't work. It has to be two different audiences.
Thank you.
I've thought of one for my staff would be something along the lines of the purposes and responsibilities, but also including an ethics, like for them, for a lot of the newer court employees that come in. I know we give them the videos, but something that's kind of an updated version, but it's, I hate to say it, but a dumbed down version a little bit for some of those people. So, yeah.
Thank you, Matt. We are close to the end of our time. Any other comments?
How many more minutes do we have?
4 minutes.
4 minutes. So this is going to be choose your own adventure. Do you guys want to see some more pictures of promising practices, hear more about kind of resources available to you? Both, if we talk twice as fast. Pictures. Okay, great. So I'm going to highlight a couple pictures we took here in Pittsburgh in Allegheny County, and maybe Tom, I don't know if you want to elaborate on these, but
depends if they're good ones.
And the photographer has requested you respond to them at the podium.
Or if you want to stand in front of the podium, you can use this.
Well,
so these we thought were really great examples.
yeah, these are good ones.
Okay, good.
Did you lose the other slide yet? No, these are good. So yeah, we have a children's room, and anybody that's coming in, whether you're a witness or whether you're a defendant or whatever, in the criminal courthouse, you can bring your children. It's run by a nonprofit, and you can drop your kids off, and they'll watch the kids up until the end of the court day. What we had to do, we had to make people produce a subpoena because some folks were dropping them off and going shopping at Macy's. But once you could produce your subpoena, you could use the children's room, and it was really well received and very, very well run, and it was something we were a little bit proud of. There's good and bad things about the building security, but in today's age, we have to have a secure building, and that comes with a downside. But we tried to get signage that was respectful and clear. And we struggled with some things, like Ann Herod said, with her heavy-duty metal bras. Yeah, what they do, actually at one point in the middle of the wintertime, they were making people take their shoes off. Now, if you're slushing through the snow in Pittsburgh, by the time you walk through the metal detector, that's soaking wet. And they were making, yeah. So we kind of unraveled that. If somebody's shoes would set the thing off, they could get wanded instead of get their socks all wet coming in. But, we try. And you're going to bring the other signs
Tom.
up on.
No. I think that's all from Pittsburgh. So I just want to show more signs. This is a signage project. We did an overhaul in Brooklyn of a courthouse there. I think signs are kind of a pleasant place to start this discussion because we've noticed that no one really gets defensive about signs, right? We're not asking people to change their behavior. You're changing something environmental. And so you can kind of change the backdrop of court, make it more welcoming, make it more respectful. The sign on the right, the court officers really were happy to help. So we said, why don't we say that? Because maybe that kind of cuts against the stereotype that court users may have about them. But the other thing that was unexpected that we noticed is that it actually kind of influenced staff behavior accidentally, right? It changed their own view of the place that they worked in. When they saw a reminder that court officers were happy to help, it just kind of showed that it was supposed to be a helpful place. And so that might be an idea for you all as you're thinking about a place to start, is it starts the conversation without really being as personal as how you treat someone more directly. These are two other examples, things we've heard in court that are subtle, but I personally love. Framing questions as open-ended questions is proven to actually elicit a response more than yes or no. People know that there's a right answer when you ask a yes or no question, right? Busy court docket. Okay, do you have any questions? No? Great. And you move along. But pausing and saying, what questions do you have, actually invites a response. This is, what day is convenient for you to return to court? The first time I heard that in a courtroom, I about fell over, because rarely is the actual litigant asked when it's good for him or her to come back, right? It's the convenience of the court and the lawyers. And maybe this will be my last one, because I think we're out of time. John's going to get the hook out. This was one of the other sites we worked with. They've actually built procedural fairness right into their interview questions for hearing officers. They get the questions in advance, and so when you show up for the interview, you're going to be asked what your judicial philosophy is about this. I mean, that's a pretty profound thing that starts to embed those principles right from the very start. So you're hiring people who get it, and I thought that was really neat. Okay, so wrap up. Let me just fast forward to the end. Resources, and I'm previewing all this other great stuff you can read at home. Oh, here, this is good. Go out there, convince others. Okay. So these are some resources from the National Center for Court Innovation. Where do I work? And Tom Tyler, who is kind of regarded as the godfather of procedural fairness, has a bunch of the research published on his website. So back to you, John.
So please join me in thanking Emily and Tom for all their insight.